Now, good afternoon, folks. Welcome to I'm Calling Out HR, the November 17th, 2020 edition, which I believe is our 10th episode, presented by Employernomics and the PEO Matchmaker, which you can find at those websites. If you didn't see it, back up. Okay, here's our sponsors, Employernomics, PEO Matchmaker, and Cureway HR. Thank you, Jennifer. And this week we have a very special guest, Michael Memberg, Esquire, from Hickox, Robertson, and is it Stunda?
Stunda.
Stunda Attorneys, HRS Law in Georgia. And the reason it's Georgia is because that's where he is right now. You're in Atlanta at this moment. Is that right?
That's correct. Just north.
And there's his website and his number. And he's also a member of our group. It's actually called Employers Resource Group of Orlando, but we had to drop the Orlando when you joined, Mike. Now I guess we're
on your horizons.
Instead of Ergo, we're just Erg. Or maybe we'll be Employers Resource Group of the Southeast, ERGSA. I don't know. We'll come up with something. So today, I want to talk about HR, of course, and you're an HR attorney, and we have been in the business together for a long time, although only recently met, which is interesting because it's a small business. And you've asked me the 5 questions you wish people would ask you, and I've got them over here. So I'm going to stop sharing so everybody can see your splendid beard and your nice tie, which I hate wearing. But I'm going to lead off with, first of all, thank you for joining us.
Thank you for having me.
It's been really good to have you as a member of ERGA, Employers Resource Group of Atlanta. And we know a lot of the same people in the PEO industry. I guess we just had never crossed paths before about 6-7 months ago, right?
Yes.
So the first question I want to ask, well, obviously, before we get going any further, folks, Michael is what I would call a workers' comp attorney. Okay, that's for your primary focus, right? Is workers' comp?
Correct. And I handle Georgia and Florida.
Right. Yeah. So, what is your approach to handling workers' comp claims?
Well, it all kind of can be put into a nutshell, which my philosophy is that the best claim is a closed claim. So, and I've found that whenever I share that with an adjuster or a self-insured employer, that usually is music to their ears. Workers' comp, obviously, most claims will get processed and picked up through the system and they'll never come my way. But obviously, when something goes sour, that's when they call me.
Should have called you before.
Well, it'd be great if they did. And I guess we'll get into that a little bit later. But just in general, they, like I'm saying, best claim is a closed claim, whether it's finding a way to move the claim forward, to get somebody off benefits, to get them to a better doctor so that we can get an opinion that's favorable to help close the claim down. Just whatever you can do to keep the claim moving forward. And then whether it, 95+% of claims are going to end up in a negotiated settlement. But so certainly if it means going to court.
By they and them, you mean the employer. Right? You're representing the employer, right?
Correct. Yes.
So we let the guys on the billboards represent the employees.
Yes, and probably by virtue of the fact that you've mentioned that there's an attorney, the algorithm will be giving banner ads and pop-ups for John Morgan, probably.
He's big down here.
Yeah, so here too. And he actually, he was just, not to give him any more press than he's already paid for, but
we'll just talk about that guy.
Yeah, but he was just profiled in one of the legal newspapers about how they doubled or tripled down on their advertising during the pandemic because all the TV stations were desperate for revenue. Yeah,
you couldn't. I mean, of course, we were all watching TV a lot during it, which is the whole purpose of declaring this pandemic. It wasn't a pandemic by any definition, but the WHO, the World Health Organization, decided to declare it one, and next thing you know, everybody's glued to the TV. So yeah, they got what they wanted. Well, but I digress. Let me get to the second question. We can get into that later. The second question is that now I'm thinking I have clients who have had claims, and several times I've asked them, do you want a lawyer? And they say, oh no, the insurance company has a lawyer for us. And your question here makes it sense to me, is why shouldn't they just go along with whoever the insurance company recommends as a defense attorney?
Well, so traditionally, and again, I'm the recipient of a lot of this, but the insurance company that you've bought your coverage through is going to be there and provide defense counsel when you are faced with litigation. So a lot of times that goes to an in-house counsel that is a captive claim, a captive firm that they all work for the insurance company. And while they certainly may know the law just as well, they're not on the same kind of they don't have the same philosophy of getting the claims closed to them, because they're not as hungry as someone working on the outside trying to make a good impression on the clients. So
they have different incentives.
yes, that's one way to put it.
That's what you're trying to say.
Yes. So but just the accounts, there is a lot of times when if you are a smaller account, you may not have the discretion, but a lot of the employers I work with are more than big enough, and they have big premiums, high self-insured retention, and it's their dollars that they may be getting the coverage through their insurance policy, and their insurance carrier is the one paying the legal bills. But when they have a good relationship and a lot of pull with the carrier, they actually can step in and request me to handle their claims, with the goal of, again, being aggressive and pushing claims toward a resolution.
So I have personal experience with this. We had a client who had the insurance company's agent representing him, and the insurance company's attorney recommended a settlement. And they were not interested in a settlement at all, because they knew they were right. They knew this person was faking. They hadn't got hurt at work. It was a back injury, one of those, right? They actually got hurt while they were working downtown as a bouncer for their night job, but the nightclub didn't have them listed as an employee, so they decided to sue their daytime employer, which was a roofer. So they came to me and said, well, we need an attorney. No, I didn't know you then. And so I referred them to someone else, and the attorney came in and said, you're going to have to pay me. And they said, how much? He said, well, it could cost as much as $10,000 to $15,000. And they said, well, the insurance company's attorney wants us to settle the claim out of court for $150,000, which we are going to have to pay because we have a high deductible. This was a PDO. We'll go with you.
Yeah.
And, with all the court costs and everything, it ended up being about, I believe, $25,000. So 25, 150. I think they made the right decision.
Yes, definitely. And, I can also tell you my experience is that a lot of some of the carriers we work with have more mom and pop type businesses, and they are a lot of times in that same situation where they see Johnny, their employee, who's claiming a back injury. They'll see him at the local gas station or even the local feed store, going out to work for another job. And, I get a lot of, why are you settling this claim? It's interesting. Like sometimes that's what you have insurance for. Actually, someone, kind of a classic example of why someone would benefit from a PEO. There was a businessman out of South Georgia who bought out this big feed and fertilizer company that had been operating for 50 plus years and had great goodwill and wanted to sell out. He didn't realize he was buying their liabilities as well. I had to have some colorful conversations with him where he was asking me why he owned this claim that took place about a month before he bought the business.
Wow.
I told him, maybe you should have hired a lawyer before you bought the company.
So it wasn't on a claims made basis.
Correct. He had those tail claims will follow you forever, especially in workers' comp.
Yes,
You know,
it's a very
yeah.
long, I learned that, that was one of the first things I learned in 2000 was it's a long-term, long-tailed business.
Yes, and then you get a lot of, now they try to say legacy claims.
Mhm.
That's the to sugarcoat it even further.
Now, I'm sure we can go back and talk about our favorite frauds, and let's do that if we have time.
Yeah, oh
I
yeah.
want to get to all your questions first and make sure you get to tell everybody how great you are, because that's why we're here, is to tell everybody how great you are. So your next question is, how does workers' comp interplay with other legal requirements?
Well, by that, what I'm referring to is federal law and other state laws. I'm based out of Georgia. I handle claims in Florida, but generally speaking, um, you've got OSHA and you've got Americans with Disabilities Act and that sort of thing. And a lot of what we're doing in Georgia is getting people back to work at a light duty job. So you're dealing with reasonable accommodations and Georgia, one big difference actually with Georgia versus Florida is there's not a direct action statute if you need to terminate someone with a workers' compensation claim, which Florida employers unfortunately have to deal with.
I want to go into that, but again, afterwards, let's remind that I want to talk about terminating someone who's currently in a claim. Okay.
But also with OSHA, it's actually been a number of years now, but they came out with a policy against blanket drug testing. But not long after that came out, they pretty much walked that back and they'll defer to a state that requires post-accident drug testing. The theory, I guess, was they didn't want to discourage someone from reporting an accident that really their otherwise unrelated marijuana usage, for example, if you're walking down the aisle of a distribution center and an anvil falls on your head, so to speak, there's really nothing you could have done, as opposed to you back the forklift into a post and injure yourself. Well, then certainly your mental state at the time could have impacted that claim.
We have one right now where the woman owner was on the job and the forklift operator ran her over. Now, he claims it was a complete accident.
Yeah.
That's
Yeah,
enough.
we get good. A lot of these distribution centers my clients have, they've really invested in good closed circuit TV. We had one not long ago where you see someone, you see them driving, but then you also see this.
Oh yeah, no, man.
And then you see them spin out and hit a post, and of course, right after that, she's denying it later in her deposition that she used the phone. But meanwhile, between the accident and the deposition, she'd gone into the manager's office complaining that she was being singled out for using her phone because she did get terminated for violation of policy.
And rightly so.
Yes.
So that gets us into another good one here. I love this question because I have my own answer, but I want to hear yours. Is what should we be doing to make our workplaces safe?
Well, there's obviously just some very basic things you can do in terms of, whatever OSHA recommendations are, for, safety equipment, personal protective equipment, that sort of thing. The idea is to look after your employees and make sure that they're following the rules. I mean, that's probably, it's almost counterintuitive, but a series of progressive discipline for safety violations. Kind of my second favorite thing that I have to tell clients is that no good deed goes unpunished. And that kind of, in the terms of a safety context, if you see someone who isn't hooked into their harness, using their cut glove, wearing their eyes and ears, wearing their steel toes, you can't let it slide. So that sort of enforcement, I know that.
I'd like to add to all that.
Go for it. Yeah.
First of all, you need a safety program, and it should be written, and it should be read and then initialed as read by each employee periodically, not just a new hire. Perhaps they should do, if it's a warehouse, like you mentioned, which is it's a high potential injury place because you've got these 4 or 5 story high things, and you've got these forklifts that go way up there. And we've all seen the videos where one guy hits one and they all go over like dominoes.
Yeah.
Obviously, in a place like that, I'm probably going to have a weekly briefing, a weekly discussion. Have you seen anything that's unsafe? And maybe have this week's special. I'd like to talk about backing the what do we call? I just said it, backing up the forklift. What are the proper procedures to do it? Certainly talk about texting, phone procedures at work. Just review it all. One thing we found is just by having procedures like that, I like what some people do, like so many days without an accident.
Right.
That encourages the employees to take part in the safety program, not just view it as, oh yeah, safety program.
Yeah. Employee handbooks, forms, policies, and procedures to get signed off on, a safety huddle at the beginning of every shift, a sit down meeting once a week or month, handouts. So many people get direct deposit, but I've told folks, well, guess what? Tell everyone that if they want their paycheck on Friday, they have to get this form. I mean, in a nice way, of course, but instead of passing out paychecks on Friday, pass out a notice that says, come collect your paycheck in the safety office. And while they're there, use that opportunity to give them a copy. For example, in Georgia, there's a posted panel of physicians that has to be up. And the point is to limit someone with an injury to one of those 6 doctors. Florida, there's no panel, and the employers have a lot more control over who the doctor is. If someone says they need a doctor and we just say, here's where you're going. In Georgia, they do get a choice. But especially now with everything going on and all the kind of issues that float to the top when you're trying to scrounge out anything. One of them in Georgia is they're claiming that the panel wasn't properly explained to someone who reported an accident. So again, getting out in front, making everyone sign off on something saying they received a copy of it is
acknowledge that they read it. I've even advised my clients in your engagement letter, and I always advise them now, use an engagement letter. When you hire somebody, you give them a letter like, this is what is expected of you on this job, and you lay out as much as you can in addition to the employee handbook. I would put things, say, by the way, before you get your ACH at the end of the week, you are going to fill out this safety form and submit it to the paymaster or whoever, the safety person, and they are not going to approve your paycheck until that is done. And as long as you put that in the engagement letter and then they sign it, well, then it's legal. It's not unfair practice at that point. It's a condition of employment.
Sure.
Yeah.
Well, I don't, I can't speak to all the states of where folks are watching over what may be required or not. But like I was saying, even if you're just using, even if you can't condition a paycheck on something like that, using it as an opportunity to hand them their paycheck in person and have a discussion with them then is,
From what I understand, as long as they agree to it up front, you can pretty much do anything. But we can get in.
Yeah, you remind me of
as long as it isn't, EPLR or the
sure
EEOC stuff.
You remind me of to make a Simpsons reference. Homer, there's a cat burglar going around. So Homer sets up an elaborate booby trap in his house, and then he invites Ned Flanders to come in, and Police Chief Wiggum says, "Well, it doesn't work if you invited him."
Oh.
Anyway,
I identify with Ned more than Homer probably on that show. So,
dokily, John.
We'll get into stuff like that. As long as we're talking TV, you said no good deed goes unpunished. So I am a Star Trek Deep Space Nine fan, and these are the Ferengi rules of acquisition. And look what Rule 285 is. No good deed ever goes unpunished. So remember that.
That'll cost you 10. That'll cost you 10 bars of gold press latinum.
Oh, you even know what it is. Very good.
Yes. Again, really showing my.
So
But I will give a shout out to Atlanta and the Coca-Cola that I love.
so
So much.
I hold on my hand, the last question. What should I be doing to minimize workers' comp exposure when claims inevitably, try saying that one a mouthful, inevitably happen?
Well, that dovetails to what we were just discussing, which is that no matter what you try to do in the best of intentions, given enough time, just there will be a claim. Even if you're thinking of that you just have people that sit at a desk all day, well, eventually someone's going to have to drive something somewhere to pick something up. Or, I personally have been rear-ended on the way to a deposition. So just because you
In
sit
your car, I assume.
yes. I told you no bad jokes.
Oh, I'm sorry. Was that?
Yes. I guess inevitably that's
I
going
was
to
just
happen.
asking if,
But fortunately, I was able to kind of pull forward and off to the side of the road as I saw it happening, and I was able to escape injury. But whether you've got all professionals or whether you have people that are up on the roof, you're going to have a claim. All the things that you can control up front, like I was saying, the panel of physicians in Georgia having people sign off on safety procedures. The other thing they say in Georgia is stupidity is not a defense. We had a case a couple years ago that went up to our Supreme Court where a lineman it was climbing up a tower, and apparently there was an old school way, so to speak, of rappelling down a big utility tower. And then there's a more updated way, which is more, step by step. Both way, you have to be trained on both ways, because if you ever had to quickly get down or quickly move down to aid another employee, you're going to need to know how to do it the old way. So of course, there was a guy who was out sick when they were doing the training, and he came back, and he'd been told, like, don't just rappel down the tower. Well, of course he did. And, the rope, just imagine like the rope going through the eye hook with no one holding the other end. That someone he smashed to the ground. Well, they did come in, and there was a standard that unless you did something just patently, obviously disregarding safety, that would even be quote unquote quasi criminal. This is for Georgia.
Did he survive?
Yes, the guy, he was around to make a claim. But unless you were doing something so egregious, there really was no way that an employer was going to prevail on a failure to use a safety appliance defense. But it's taken a lot more of a reasonable toll or turn, so to speak. So, if you're laying out your safety procedures, we have a lot better shot of prevailing on the claim for disregarding them than we did a couple years ago.
So this is a good time to talk about our group, the ERG, because we have people in the group that can help with all that. We have you, an attorney, who can help from the legal side. We've got Jennifer and Milan, HR experts, who can, and even though I have the same letters they do, I'm not as a specialist as they are. They are doing it every day. They're very certified. I can help with transmitting some of the risk to a PEO, because that's what we do. We put people as a PEO to transfer the risk over to the PEO and bring in professional experts to help and deal with things like this. So we have an insurance agent who can help you get the right insurance. Our group, that's why we all work together. We want to present a front or a team, so we can go to, say, your employer or my employer, your client or my client, who are employers, and say, listen, we are here to be your resources to help make your workplace safer. But more than that, I mean, that's important. Safety is important. Obviously, nobody wants to get anybody hurt. But one thing that a lot of employers don't realize is the expense associated with doing it wrong.
Oh yeah.
Yeah, I could give you an example of a local police department over here, over on the East Coast, where they decided to use their workers' comp as their retirement plan. And one of these senior sergeants or something had a back injury. It just so happened, so coincidentally happened at 19 years and 6 months. So he's out. He's on full disability for workers' comp. They're paying for everything, 2/3 of his wages, paying his chiropractor and all that. And in court, the attorney, who would have been you if you were representing the employer, said, this guy just did an Ironman. How can he do an Ironman with a back injury where he can't work? And his attorney tried to argue, says, well, that's therapy. That's part of the therapy he's been assigned to do, is running, swimming, and bicycling. And I just wish, I don't know, never did find out how that ended up. I heard that one from Heather. Heather McLeod, right? She used to work with Torben.
Oh yeah.
Yeah, so Ham, he called her, Heather Ann McLeod. So she told me that story, and I would love to know how that ended up, because how do you justify doing an Ironman? Even a single marathon, nobody with a back injury is going to get halfway through a marathon. No way. And I think you and I both know that, I think it's common knowledge around here that 50% of the claims in Florida are false. They're fraudulent claims.
Just 50?
Well, 50% overall. In the municipalities, it's supposedly closer to 80. What do you have? What numbers do you have?
Well, it's rare actually I would get a case that's so patently fraudulent, because usually they haven't made it, they get thrown out they get worked out of the system before they come to us. Unfortunately, Georgia is very lax on prosecuting these claims. I mean, it's just, whether it's outright fraud or just no way that it would ever be found compensable, but they're still pursuing it. Georgia does not assign or assess attorney fees against claimants anywhere near to the level that they probably should be. In Georgia versus Florida, the attorney fees are not guaranteed for the claimants' attorneys. So,
that's changed. That's changed in Florida since Rick Scott came in.
Well, you get in Florida, if you file a PFB, a petition for benefits, and you end up getting it, your attorney's gonna get fees at the responsibility of the carrier. In Georgia, there's still a level of, they have to prove that you're unreasonable. So usually just by getting a third-party medical opinion, an IME, and having some leg to stand on, that's enough to keep us from having to pay the add-on fees. The PICA is the bane of employers' existence in Florida, the penalties, interests, claimants' attorney fees.
Well, I do know that the attorneys I've talked to down here who are no longer in business, so recently retired, which is why you came along at the right time, because this lady I was working with retired. So glad to have you on board. But she told me that she was now frequently getting the fees recovered from the prosecuting attorney's office. The not prosecuting,
Claimants' attorneys.
the plaintiff's attorney. Yeah, the people who were suing for workers' comp, that once in a while, if they find out that it was a fraudulent claim, she said she would actually get her fees paid. And of course, it would go to the insurance company, but the insurance company said, hey, great, thanks for giving us some money back.
Right.
That was nice. So, and I'd like to see that, because it bothers me when people like that guy we mentioned before, there's no risk. They tell them no recovery, no fee. The only thing they're paying, well, actually, I don't think they pay anything. If there's court costs, they do charge that to the client. So they have nothing to lose. Might as well go in there and ask for the world. And if they get, ask for $1 million, and if they get 100,000, that's 90,000 profit or whatever it is.
Well, he's running a specific ad that says you talk, not all attorneys are the same. And, they've gone back to that cliche where they have an actor playing the insurance company's attorney. And then they have, this one actually was an actor playing like a bad, cheap lawyer.
I did.
He's on the phone with the adjuster and they're laughing. And he says, you know what, let's just $10,000 on this claim. And then that guy comes on the screen and tells you that not all attorneys are alike. And, we've got all these claims that if they hadn't settled it for $10,000, we could have gotten you 100.
Well, then now one of his proteges, Dan Newland, his protege, John made a very wise decision, that other guy, and invested in and bought 33% of Dan's business. So he's now helping him advertise. And now his billboards say, Dan got me 700,000,
Yep,
for a while there, the bar told them they couldn't do that for a little while. Says you can't put that up there. So for a while, there was just people holding a check with the numbers blanked out and saying, thanks, Dan.
It has to be the real person.
Yes, and it is, and that's how they won the case. They came back to the bar and said, hey, look, we're showing these are actual client testimonies. We're allowed to use client testimonies.
Yeah, and in Florida, I think the rule is that your face has to be on your advertisement. An actual attorney.
They are the two people sitting there holding the check,
Yeah, no, of the actual attorney in Georgia.
Dan got me $1 million.
In Georgia, you just have the, been hurt, call this number, as opposed to requiring the attorney to actually put their face up on their own ads.
Oh,
there's one in Tampa.
The attorneys are required to put their faces on too?
I think so.
Oh, is that why we keep seeing them? Okay, I thought.
Yeah, when you're driving, because my wife's from Tampa, so I'm always driving up and down that I-75 corridor. And there's one guy, no need to say his name, but it says his name, his picture, and it's Harvard law graduate. And I don't know if Harvard's going to call him to tell him to take those billboards down.
Well,
okay,
probably
you're a Harvard law graduate.
He probably donates a lot of money to Harvard. Let's face it, Harvard's just for university like everybody else, and they
still paying for
on that endowment.
Well, I don't know if you saw just yesterday, this businessman out of Maryland, I think, got caught up and indicted for paying $1.5 million in bribes to the Harvard fencing coach.
Imagine that.
So his kids could get in.
Oh yeah, well the SAT thing too. Remember the test scores?
I mean, it's whatever happened in the old days of just giving a lot of money to the college and them letting you in. I don't know.
My dad was shaken down. He's a Colgate grad. I wanted to go to Colgate because it was nearby. Because my dad went to Colgate. My SAT scores were great. They were really high. My achievement test scores were great. They're really high. My grades, not so much. Like a 3.0 average. I had all B's and a couple A's, a couple C's. So they waitlisted me and they said to my dad, said, well, we could really use a new wing at the library. And he calls me up, he says, they're shaking me down. And you can imagine my dad's just an older version of me. He was just incensed. They are shaking me down just so that I can get my son into college. And he's calling up trustees and everybody and yelling, we don't know anything. To make a long story short, I didn't go to Colgate. That's a topic for another. We're getting off topic. Is there anything you want to throw in here at the end? Because we're now at 30 minutes, which seems to be a good time to call to an end. What's in the future for you? What's coming up soon that's exciting that you're seeing, or what do you see happening in the field coming up soon because of recent events?
Well, I tell you what, I'd really like to see in Georgia an expansion of the PEO world. And, we need people up here that are aware of how PEOs run and work, and people that could open up in Atlanta. There's opportunities to get people here signed up for PEOs. And I know that, with maybe we know somebody like PEO Pros that is looking to open up in Atlanta, just anything, because I'm seeing clients that are migrating. Yeah, Employer-nomics. Yeah, they're migrating organically up into Georgia. You know, I don't want to say finally, because Georgia, obviously, I think something for the last 10, 15 years has been the U.S. Chamber of Commerce's top place, top state for businesses. We've got some of the lowest weekly rates for workers' comp benefits in the country. They've gone up a bit in the past couple of years, but it's not $1,000 like you see in a lot of states. It's right now the maximum is $675. But in any event, you know, I'm really looking forward to see Georgia become more of a PEO opportunity for just for the people of Georgia in general. But it's a great business model. It provides for a lot more benefits for people that, you know, we don't know what's going to happen in terms of how healthcare is going to be provided to people in the future. But I think everyone likes having their own insurance carrier as a benefit of their employee. Of, you know, not everyone, but it's a lot of people would like things to kind of stay where their employer is their one arranging for their health insurance, and PEOs provide a great opportunity for that because they're, you know, you could have someone that is a small employer that may not really be able to provide many benefits to their employees. Whereas, you know, for just the administrative costs of a PEO can all of a sudden compete against a big employer because they can now provide 401k, health insurance, disability insurance, that sort of thing.
It's so true. It's something we're focusing on lately, not just health insurance, but all types of health care. We've got telemedicine is a big thing right now,
Yeah.
especially now that we're all at home or more at home than we ever have been. We can use, well, what are we using right now? Zoom. Now, the one company we work with, Doctegrity, has their own version of Zoom where people can get on the app, schedule an appointment, and usually within about 12 minutes, they're on a video call with a doctor. And it is eliminated, according to the health carrier we talked to, it's eliminated, they estimate between 50 to 60% of all doctor visits just by using this, and therefore reducing the cost of the health insurance. Then there's other things like defined benefit plans, which PEOs are great with, because they can provide a fixed benefit plan to their employees, which isn't underwritten because it's a fixed plan. Doesn't matter if they have pre-existing conditions. Yeah, so you're 100% right. That's something we're focusing on a lot here at Employer-nomics. I'd like to work with you on that. I'd also like to get all of my clients to have an attorney to defend them should they ever have a claim. So we're going to be introducing you, of course, whenever, as soon as anybody mentions, I need an attorney, we refer you right away. There hasn't been much lately because, you know, the courts have been closed. They're all doing everything virtual. So as soon as the courts open up, I expect your life is going to pick up again.
You know, I've had we call it a hearing in Georgia for a workers' comp trial, but you know, most of them are going to settle. But we had one in person about 6 weeks ago. So you know, I've been in court. It's currently discretionary of the parties to do a Zoom hearing or not. Right now, you know, Zoom is great for a lot of things, but you know, when you want a judge sizing someone up in person, especially comparing them to my credible witnesses, you know, we're going to want in person.
We need
but
to
it could be
back in about, say, 45 to 60 days to see what's changed. Does that work for you?
Sure, absolutely.
All right. This has been really good, Michael. This is very educational. We've learned a lot, and I'm sure our viewers have learned a lot too. Let's see if anybody asked any questions. I wasn't checking that. Nope. There's some people who watched and said they gave us thumbs up, but nobody's asked any questions. So you're doing well. So, folks, thanks for joining us here on I'm Calling HR. If you want to contact us, here's how you do it. info@employernomics.com, the website contact form. There's our phone number. And please send us questions, suggestions, topics, and if you would like to be a guest. If I would do this every Tuesday if there were enough people who wanted to be a guest. I really would. So, Michael, if you can recommend anybody, let us know. You were great. It's fantastic. And I believe next week we have Milan Roy, who I imagine is going to be very interesting as well. We're getting into the real HR part of HR, isn't it? It's funny. What's the show called? Oh, yeah. I'm calling HR. All right, folks. Thanks for joining us. And we will see you next week. And I'm calling HR. Say goodbye to him, Michael.
Thank you very much, everyone.